Thank you, Matthew. I'll jump straight into the point of my talk, which is that international waters are set to become the next battleground over patents and disclosure of information and free use of scientific information. So international waters are the areas beyond national jurisdiction which comprise the high seas and the seabed below, which is essentially around 60% of the world's oceans and 40% of the surface of the planet. So it's a fairly large area, and these are beyond national jurisdiction, which means that countries, there are no sovereign rights over the waters and the biological resources within them. So they're the situation that we've come across is that these areas are essentially means that the biodiversity within it it's a free-for-all. So countries are concerned that there is no governance in these areas, so they're coming together to negotiate a treaty, which is an implementing agreement under the UN Convention on the Law of the Sea, and it's in relation to the conservation and sustainable use of marine biological diversity in areas beyond national jurisdiction. So I'm a delegate on one of the delegations for this treaty negotiation, and the president of the negotiation has released last week draft text which is about to throw a bit of a hand grenade into into the negotiations in August, because essentially it's highlighting the tension between the countries that don't want intellectual property to be affected by an environmental treaty and the countries, developing countries, that do want intellectual property to be affected. So it's a very interesting debate, and that is what I will focus on today in this talk. So first, what I'll do is I'll go through what I mean by marine genetic resources, the sorts of governance arrangements that are around these resources within national jurisdiction, and the proposed arrangements beyond national jurisdiction, and then talk about how it relates to patents and scientific information, and that tension between wanting to have a hands-off approach to IP and the countries that want to affect it through environmental treaties. So what I'll also do at the very end, though, is to go through some sort of middle ground options that countries can consider. So what we're talking about here are the marine genetic resources, and these are biological resources that are used for their genetic material potential. So it's not, for example, for capture fisheries where you're simply using the product for the fish fillet, for instance. It's to do with the research and development aspects of using those materials and coming up with things like the patent pharmaceuticals, say from sponges, to create drugs for cancer treatment. So it's not in relation to biotrade where you're simply trading, say, the oil or trading the fish. It is to do with the research and development elements of the resources. So there are four kind of forms of marine genetic resources in this debate, which the biological resources can be in situ, which is in the waters. They can be ex situ, which is in research facilities, in gene banks and so forth. Then we have information that's used separately to the physical materials, and that's digital sequence information. So that's called in silico sort of forms. Then we also have traditional knowledge associated with genetic resources. I won't talk about that, but that's a huge area to talk about. But today I'll focus on the scientific side. So the Convention on Biological Diversity basically created this concept of access and benefit sharing to regulate the use and exchange of genetic material. So under this process, it's a transactional process. So we have the user, which is, the provider country will provide the physical materials, so the raw genetic resources to the user. In return, for their prior informed consent, they have to agree to share some of the benefits from their use with the provider. So it's this closed sort of transaction. So under this system, then there's sort of the two streams. We've got the access side, which is a government sort of government process where It regulates how those resources can be accessed, used and transferred and so forth for research. Then we have the benefit sharing side, which is a contractual process, and that talks about the conditions in terms of what sort of benefits they'll send back to the provider. The issue for the areas beyond national jurisdiction is that there is no provider. This concept is based on a transaction between countries and the people who want to use their resources. So the relationship then between ABS and patents is that a lot of people are concerned that access will be restricted to genetic resources by broad patent claims over these materials, which will stop them from being able to use them for their own activities. On the other hand, some countries are restricting, they're imposing conditions on claiming patents. For example, in India and more developing countries are putting those sorts of aspects into their access and benefit sharing laws, not necessarily their IP laws, which we'll talk about a bit later. But in terms of that second component, the benefit sharing, it's intellectual property is often sort of held out to be something which is, it's often promoted as a form of benefit sharing. So it's something that it's a positive aspect of IP. But then on the other hand, some providers are basically trying to stop, prevent patent claims, often unsuccessfully through these contracts, because patent law is different to contract law. So in terms of, the patent examiner doesn't have to take into account or wouldn't take into account any contractual obligations that the applicant has. So in terms then of the interesting trends for marine genetic resource patents is the reason I'm showing you these sorts of trends is because it's relevant for the way that the international community can regulate it for ABNJ, is that most of them cluster around specific properties of those organisms, so things like micro or antifreeze proteins for transgenic fish or bioluminescence for research tools and so forth. There's very few sort of new inventions. They build on other people's inventions around a couple of properties. There is this massive concentration as opposed to a lot of terrestrial uses of genes. There are only a couple of patent, very, very strong concentration of the holders. So there's nearly 50% is in Germany and BASF in one company of sequence patents. So it's very much a closed sort of group of people, of companies. But the other interesting trend, there was a study last year which found that there was a massive spike of patent claims during the Nagoya Protocol negotiations, which is the implementing agreement for the CBD. So there is this, relationship between patent holders being concerned that access and benefit sharing will affect their ability to patent and so forth. So there's quite a close relationship between the two regimes. So just to talk a little bit about the jurisdictions. So like patent law, access and benefit sharing is territorial in nature. So in terms of the CBD's scope for regulating genetic resources, it applies to the territorial seas, EEZs and the continental shelf in terms of the physical materials, but also activities of their nationals in areas beyond national jurisdiction. So, but here you can see that there's essentially no regulation at all for the genetic material within that 60% of the oceans. So this implementing agreement is trying to fill that gap in UNCLOS. I won't talk about the current approach because we don't really have time, but essentially it's just a patchwork of obligations that don't really help in terms of protecting biodiversity in the 60% of the oceans. Mainly because a lot of the obligations are ineffective. So the UN said that the technology transfer obligations, for example, sharing information and technologies, is one of the greatest implementation gaps. So one of the reasons for this is this idea that those obligations are subject to having due regard for all legitimate interests, including patent holders. So essentially people are looking at IP in terms of it being an issue for governance. So I won't go through what the actual draft text is looking at for marine governance, but you can see that it's based on the location of the materials, and yet the benefit sharing and the monitoring system is based on, is sort of covers across the board all of these different areas. But what some countries are trying to do is use IP for benefit sharing and monitoring because of these different sort of different types of systems that they're proposing for accessing materials. So some of the key, I'll just talk about three, I guess, key issues for the negotiators. Primarily that we have issues of equity. So countries are saying that, it's too far away for me to read, that essentially the technologically disadvantaged countries are saying, well, you're blocking us out from using these resources to be able to create our own inventions and build capacity in these areas. So they're wanting a greater share of the benefits as well of those inventions, and because they're based on common property resources. The second issue that they tend to have is that these treaties only commit states, the obligations only commit states, so and not private entities. And in this case, the private entities are quite powerful. They're fairly concentrated in number, and they're quite powerful. So in terms of geographical constraints, we have that situation I was talking about before, that they're trying to regulate different types of resources in different jurisdictions. So they have this issue about tracing the origin of the materials as well as the sequencing information that comes from the materials. So basically nearly 90% of patent applications don't disclose the origin of where they get the genetic material from. So it could be within national jurisdiction or beyond national jurisdiction. So as of last week, the President released this a proposal in terms of draft text that will be discussed in August. And some of the key elements are they're proposing that there be no patent claims over these different forms of marine genetic resources unless the applicant modifies it based on human intervention. But here we have a few issues in terms of their, obviously TRIPS has 3 elements of patentability. So we've got new, involves an inventive step and is capable of industrial application. So they're kind of, in a sense, trying to rewrite that, which will offend TRIPS. And so there'll be a big debate about that. They're also proposing that you can't have a claim unless you disclose the origin of the genetic material. And here, what a lot of developing countries are trying to do is bring this debate they've started in TRIPS, in the WTO forums, for using disclosure of origin to assist with the monitoring and benefit sharing of these genetic resources. So there's a deadlock in that space, and they're moving the debate over to this new treaty. So it'll be interesting to see how that pans out. They're also proposing that any applicant needs to consult with this technical body that they will set up under the treaty and engage in benefit sharing agreements. But here again, we've got that issue where patent law is separate to contract law. So it's quite comprehensive. There's a massive, sort of difference between certain countries, certain developed countries like the US, who are saying hands off. There's no, we can't have any kind of impact on intellectual property regimes through this environmental treaty. Developing countries are saying, no, we can use it as a monitoring mechanism and a benefit sharing mechanism. So in terms of that debate, moving to the side then, because the positions seem to be entrenched, some middle ground could be in terms of that first issue about equity. They're already flexibilities under TRIPS that countries could, that users could exploit in terms of using the genetic material for other inventions under experimental use exceptions. There's also this recent softening of WTO considerations. There was in the Australia tobacco case, and that sort of brought in other aspects into consideration. So there's a possibility for bringing in down the track, opening the door for biodiversity policy. In terms of regulating those private entities, they could use the concentration to their advantage, because if there's only a few players in that area, well, they could have direct contact with them through these negotiations. But from so far that I haven't seen any, well, there haven't been many voices on the floor at all from industry. They're not sort of represented there necessarily. And so I guess they'll probably be talking about these issues with them behind closed doors, some certain countries, but it seems to me that they need to actually be involved in the development of these arrangements to see if it's practical for the sectors. And so another option could be moving towards that global compact idea that they have for biosafety, which is the flip side of sharing genetic resources. It's where you're protecting risk from, or protecting harm from the use of genetic GMOs. So here it could be an opportunity to have a social license to operate, in the sense that they're creating their own compact. The industry creates its own sort of compact to say that they'll follow above the minimum standard of, that this treaty comes up with, in terms of behaviour and what they do with the patents from areas beyond national jurisdiction. And to overcome some of those geographical constraints, there are options for example, market-based incentive systems like an ABS certification system. And there are other forms of multilateral systems that could be used, which I won't go through now because in the interests of time. But there are ways to get around these geographical constraints. So the point that I'm making is that this debate has the potential to derail the whole process, because the parties are entrenched in their positions. There doesn't seem to be any middle ground that they're necessarily looking towards. And the danger is that they're distracting the parties from creating, looking at other mechanisms or other aspects that actually would contribute to the conservation and sustainable use of marine genetic resources, because literally the intellectual property aspect is a drop in the ocean compared to all the other uses of marine genetic resources that are out there and the activities that relate to it. So it seems that it's probably time to reframe the debate and move towards some more of a peaceful coexistence between the two regimes, in the interests of sharing information, ideas and strategies to look after the oceans.